Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study Case Law No. 34/2020/AL regarding the rights to establish a testament of deciding about the compensation for the state's recovery. Part 1 Source of the case law, Part 2 Overview of the case law, Part 3 Content of the case, Part 4 Assessment of the court, Part 5 Rules. The case law was adopted by the Council of Judges of the Supreme People's Court on February 5, 2020 and published under Decision No. 50/QDCA of the Chief Justice of the Supreme People's Court on February 5, 2020. Source of the case law. The Cassation Decision No. 58/2018/DSGDT on September 27, 2018 of the Collegial People's Court in Hanoi on the civil case of requesting on declaring the notarized document is invalid in Vinh Phuc Province between the petitioner Mr. Tran Van Y, Notary Office M, the defendant, and Mr. Nguyen Van D1, a person with the related rights and obligations. Overview of the content of the case law. 1. Overview of the case law. The land use right legally established by a person recovered by the state when that person was alive is considered a case of compensation. 2. Legal solution. In this case, it should be determined that the recovered land use right was guaranteed by the compensation value. Thus, the person owning the recovered land was entitled to establish the testament to dispose of that compensation. Key words of the case law. 1. Recover the land. 2. Compensation when the state recovers the land. 3. Inherited. 4. Testament. Content of the case. According to the petition on June 26, 2013 and the testimonies in the procedure, Mr. Tran Van Y, the petition, stated, in 1987, he was transferred the land plot number 28, map number 13 located at M area, N Ward, V City, Vinh Phuc Province by Ms. Nguyen T.C.T.T1. Regarding the transfer of the land and the crops, he and Ms. C obtained the certificate of the People's Committee showing that he was allowed to live with Ms. T1. In 1988, the People's Committee agreed that he can register his name to this land and turn into another land because this land was bordered by a lagoon inconvenient for taking care of children. Because he couldn't afford to build a house, he did not exchange the land. In 1998, he and Ms. C prepared the papers to transfer the above land plot for 140 million VND. Although the payment was not written by the parties, there were two persons witnessing his payment, who were Ms. Nguyen TB, dead, and Ms. Tran TK, D Group, D Ward. When transferring, they established a contract on purchasing and transferring the land use right dated February 8, 1998 and summoned to the People's Committee. In 2008, his family did not live at this land anymore due to land clearance. In 2009, there was a dispute between him and Mr. Nguyen Van D's family. In 2013, he was told that the Notary Office M had notarized Mr. Nguyen Van D's testament and the written announcement of Mr. D and Ms. T1's testament dated January 26, 2011. According to the aforementioned papers, Mr. D had the right to own and use a part of the land plot number 28, map number 13 located at M area, N Ward, V City, Vinh Phuc Province. Mr. Nguyen Van D1 was the heir of Mr. D and Ms. C for the land plot number 38, map number 13 with the area of 299.8 square meters in area M. The notarization was illegal and impacted the legal rights and interests of his family, so he requested the court to declare the 02 aforementioned notarized papers invalid. The representative of the defendant, Notary Office M, stated that, on January 14, 2011, Mr. Nguyen Van D1 took Mr. Nguyen Van D to the Notary Office M and requested the testament of Mr. D to be notarized. According to Mr. D's declaration, he and Mrs. T1 got married and did not register for marriage. Since Ms. T1 could not give birth, Mr. D got married to another person, but Mr. D and Ms. T1 did not divorce. The house and land plot number 38, map number 13 in area M were the common property formed in the marriage period between Mr. D and Mr. C. Mr. D and Mr. D1 presented the papers proving the assets enclosed to the testament for the notarization request, the testament of Ms. T1 notarized by the People's Committee of S Ward, K District, Hung Yen Province. Accordingly, Ms. T1 recognized the assets on the land plot number 38, map number 13 was the indivisible common property of her and Mr. D, so she asked for the notarization of her testament. The Notary Office M considered her testament to be legal, the original papers of purchase showing that Mr. D purchased the land from Mr. D, the paper of purchasing notarized by the People's Committee of Commune T, then he exchanged with Cooperative N for the file M, now as the land plot number 38, map number 13, official letter number 405/UB&DTD of the People's Committee of Vinh Phu Province on settling the citizen's complaint. Official letter number 372/UB&DKNTC dated February 7, 2011 of the People's Committee of V City on responding the complaint of Mr. D. At the time of establishing the testament, Mr. D was over 90 years old, but he was still conscious, lucid, and well aware of his action. Mr. D1 was the only one alive in Mr. D's first level of heirs, comprising his wife, his children, and his parents. There was no one who was the minor, less brain, weak and unable to support himself or herself according to the provisions of civil law. Thus, it was completely in accordance with the civil law provisions on testament that Mr. D had a testament giving all his assets to Mr. D1. After considering the aforementioned issues, the Notary Office M determined that the Mr. D's testament establishment was completely plausible and the testament's content was lawful, so they notarized Mr. D's testament. On January 15, 2011, Mr. D came to the Notary Office to fingerprint to the testament. Before fingerprinting, the notary read aloud the whole testament. He totally agreed. After Mr. D died, his testament came to effect. Mr. D1 came to the Notary Office and asked for the testament declaration, and the Notary Office declared the testament in accordance with the law provisions. In the process of notarizing and declaring Mr. D's testament, the Notary Office was not told about the disputes related to the land. The notary offices suggested that the court considered and settled in accordance with the law provisions. The person with the related rights and obligations, Mr. Nguyen Van D1, stated his father, Mr. D, and his mother, Ms. C, got married to each other in 1957. In 1959, his parents bought a land from Mr. D in S Group, D Ward, V Town. Because his parents did not have any child, in 1969-1970, Ms. C agreed that Mr. D got married to Ms. H, Mr. D1's biological mother, who lived in M area, N Ward. In 1976, Mr. D bought the house number 24N and worked as a barber. Ms. T lived in the house No. 60N, and Mr. D and Ms. H lived together in the house at M area. After his birth, Ms. H died. In 1968, Ms. C sold the house number 60N and bought another in C City. In 1986, she sold the house in City C and moved to Hung Yen Province. In 1988, Ms. C came back to V Town and built a house on the land plot in Lane 3 of T Group. Because there were many graves on this land, she moved to M area with Mr. D and his children. From 2006, Ms. C came back to Hung Yen. Mr. D1 and Mr. D managed the land at M area, but Mr. Y disagreed. Mr. D1 did not agree that Mr. Y requested the court to declare the 02 aforementioned notarized documents invalid. In the civil first instance judgment number 10/2014/DSST dated April 28, 2014, the People's Court of Vinh Yen City, Vinh Phuc Province decided, 1. To declare the notary text of Notary Office M of Vinh Phuc on January 15, 2011 for the testament of Mr. Nguyen Van D, born in 1919, and notarized document of the written publication of the testament on January 26, 2011, which announced the testament on December 16, 2009 of Ms. Nguyen T1 T, born in 1924, and the testament on January 15, 2011 of Mr. Nguyen Van D, born in 1919, invalid. 2. On the court fee. On May 12, 2014, Mr. Nguyen Van D1 appealed that he did not agree with the civil first instance judgment. In the civil appellate judgment number 23/2015/DSBT dated April 27, 2015, the People's Court of Vinh Phuc Province decided to uphold the whole civil first instance judgment of the People's Court of Vinh Yen City. On April 11, 2016, Mr. Nguyen Van D1 filed a request on reviewing the appellate judgment mentioned above according to the cassation procedure. In the decision number 08/2018/KNDS dated on April 26, 2018, the Chief Justice of the Collegial People's Court in Hanoi protested against the appellate judgment number 23/2015/DSBT dated April 27, 2015, the People's Court of Vinh Phuc Province, and requested the Committees of Judges of Collegial People's Court in Hanoi to cancel the whole civil appellate judgment mentioned above and the civil first instance judgment No. 10/2014/DSST dated April 28, 2014, the People's Court of Vinh Yên City and hand the case over to the People's Court of Vinh Yên City, Vinh Phuc Province for retrial under the law provisions. At the cassation trial, the representative of the Collegial People's Procuracy requested the committees of judges of Collegial People's Court in Hanoi to agree with the decision to protest of Chief Justice of the Collegial People's Court in Hanoi. Assessment of the court. Mr. Nguyen Van D and Ms. Nguyen T.C., also known as T1, lived with each other since 1957 without registering their marriage. In 1959, Mr. D bought a land at M area from Mr. Nguyen Van D, then exchanged it with Cooperative N for a plot of land in Field M, which is now parcel number 38, map number 13. Around 1969 to 1970, Mr. D lived with and had a child, who was Mr. Nguyen Van D1, with Ms. H. On December 16, 2009, Mr. C established a testament with the content of leaving a part of the property which was the real estate in land plot No. 38, map sheet number 13 to his son, Mr. Nguyen Van D1. On January 15, 2011, Mr. D made a testament at the Notary Office M, Vinh Phuc Province, with the content of leaving his assets at the above-mentioned plot of land to Mr. D1. In case the state recovered and compensated for property on the land, Mr. D1 was entitled to receive such amount of compensation under his name. On September 7, 2010, Ms. C died. On January 21, 2011, Mr. D died. After Mr. D and Mr. C's death, on January 26, 2011, the Notary Office M of Vinh Phuc Province, hereinafter abbreviated to Notary Office M, issued a written announcement of the testament on December 16, 2009 of Ms. T1. And the testament on January 15, 2011 of Mr. D with respect to their heritage, which was the land plot number 38, map sheet number 13, area M, ward N, city V, Vinh Phuc Province. Mr. Tran Van Y stated that he bought the land plot number 38, map sheet number 13 at M area from Ms. C from 1987. In 1998, the two parties established the agreement on selling and transferring the land use right and the contract of transferring the land use right. Thus, that the Notary Office M notarized the testament of Mr. D and the written announcement the testament of Mr. D and Ms. C impacted his family's legal rights and interests. So, he filed a lawsuit to request the court to declare the notarized documents mentioned above invalid. According to Article 45 Law on Notarization 2006, the people having the right to request a court to declare a notarized document to be null and void are a notary, an applicant for notarization, a witness, a person with related rights and interests, and any competent state body. To prove his rights and obligations related to the notarized document and rights to file a lawsuit, Mr. Y presented the accreditative dated May 20, 2005, an amount of 100 million VND, contract of authorization dated on June 23, 2009 between Ms. C and Mr. Y, the agreement on selling and transferring the land for living dated on February 8, 1998, the contract of transferring the land use right dated on February 8, 1998 between Mr. Y and Ms. C, enclosed to the petition. The land plot at M area was the common property of Mr. D and Ms. C, but in the document presented by Mr. Y, there was no opinion of Mr. D. In the case that Ms. C arbitrarily decided about the common property without Mr. D's consent, the legality of the contract of transferring the land use right between Ms. C and Mr. Y should be reconsidered. In the process of settling the case, the first instance court and the appellate court have not considered and assessed the documents and evidence provided by Mr. Y, have not assessed the contract of transferring the land use right between Ms. C and Mr. Y to determine Mr. Y's rights and obligations to the heritage, which was the land plot number 38, map sheet number 13, and his rights on filing a lawsuit to request the court to declare the notarized documents null and void. But have considered and assessed the form, content and procedure of these notarized documents to declare that they were null and void, that was not sufficiently grounded, affecting the legitimate rights and interests of Mr. Nguyen Van D1. Besides, the heritage Mr. D and Ms. C left was land use right of the land plot number 38, map sheet number 13, which had been recovered under the decision number 1208/QDUB&D dated on July 21, 2010 of the People's Committee of V City. However, the land use right of the people having the land recovered was protected by the law on land. Mr. D and Ms. C were entitled to establish a testament to leave the above property to Mr. D1. It was not appropriate that the first instance court and the appellate court, based on the judgment No. 45/2009/DSPT dated on May 22, 2009 of the People's Court of Vinh Phu Province. While this appellate judgment showed the trial panel's decision on cancelling the first instance judgment and suspending the case settlement, to determine that when Mr. D established the testament, the heritage, which was a part of the property, the real estate located at plot number 38, map sheet number 13, no longer existed. Thus, in the process of a case settlement, it was necessary to consider the legal value of the real estate contract between Mr. Tran Van Wy and Ms. LUient T C and the legality of the testaments made by Mr. D and Mr. C, as well as the legality of the written announcement of the testaments, to thoroughly resolve the case and ensure the rights and interests of the involved party. Rules. According to Point A, Clause 1, Article 337, Clause 3, Article 343 and Article 345 of the Civil Procedure Code 2015, 1. Cancelling the civil appellate judgment number 23/2015/DSPT dated April 27, 2015 of the People's Court of Vinh Yên City, Vinh Phu Province on the civil case of requesting on declaring the notarized document is invalid between the petitioner Mr. Tran Van Wy, Notary Office M, the defendant, and Mr. Nguyen Van D1, a person with the related rights and obligations. 2. Handing the case over to the People's Court of Vinh Yên City, Vinh Phu Province for retrial under the first instance procedure in accordance with law. The heritage Mr. D and Ms. C left was land use right of the land plot number 38, map sheet number 13, which had been recovered under the decision number 1208/QDUB&D dated on July 21, 2010 of the People's Committee of V City. However, the land use right of the people having the land recovered was protected by the law on land. Mr. D and Ms. C were entitled to establish a testament to leave the above property to Mr. D1.